Hello, everybody, and welcome back to Workplace Compass. Over the next few episodes, we are going to be focusing on the trade union and industrial relations provisions of the Employment Rights Act, which are provisions that are quite interesting, actually, and are not necessarily being talked about as much as some of the other parts of the Act. So my name's Jess. I'm a legal director in the employment team here at VWV, and I'm joined today by Lorna and Ellie.
Thanks, Jess. Hi, I'm Lorna, a legal director in the employment team with a particular interest in trade unions and industrial relations.
And I'm Ellie Boyd, a partner in the team and an independent schools specialist.
And across this mini-series, we are going to break down some of those key trade union and industrial relations reforms under the Act. And we're also going to explain what they're going to mean in practice for employers. So today we are starting right at the beginning of the union relationship before recognition and before industrial action. We're going to look at two key changes under the Act. So that those are the new rights of access and also the duty to inform workers about their right to join a union. So, Lorna, should we start with the right of access? Do you want to take us through what this is in practical terms?
Yeah, well, at a high level, this introduces a new statutory framework allowing trade unions to request access to a workforce so that they can meet and support, represent, and recruit workers, and also facilitate collective bargaining. And that isn't just physical access, it can also be digital access, for example, through email or online meetings. And it's also worth noting that this right of access is focused on engagement and representation, so it doesn't extend to things like organising industrial action.
And the process is quite structured, isn't it?
Yeah, very much so. The consultation sets out a clear staged process. So once a union makes a request, the employer has a short period, proposed to be 5 working days, in which to respond by either accepting or rejecting the request in whole or in part. And if there isn't any agreement at that stage, well, then there's a negotiation period, which is proposed to be around 15 working days for the parties to try to reach agreement. And if that still doesn't resolve things, either side can then refer the matter to the Central Arbitration Committee, and they will decide whether access should take place and on what terms.
Okay, so this isn't something that employers can simply ignore or avoid then.
Oh no, employers will need to engage with the process. An employer can refuse an initial request, but then that just moves things into negotiation, and ultimately the CAC can step in and determine the outcome. So the overall framework is designed to ensure that unions are able to reach workers while still allowing employers to raise concerns about what is reasonable in their particular workplace.
Thanks, Lorna. And Ellie, then, and from a school's perspective, I'm just wondering what are the key takeaways to you about the right of access for unions?
Yeah, I think practicalities are going to be key. The framework recognises that access can be physical or digital. And in many cases, I think digital access may well be the most straightforward way of facilitating this in schools. Where physical access is requested, I suppose issues like safeguarding and supervision, they can usually be managed through the way that the arrangements are structured rather than, preventing the access altogether.
Yeah, that's true. So I suppose whether it's physical or digital access, there's going to be ways to make it work. So I'm wondering then where you see the real pressure points might be within the education sector.
Yeah, I suppose it's more about how regular and ongoing that access could be. So the consultation suggests that access could take place on a weekly basis and that unions may only need to give relatively short notice, potentially as little as a couple of working days before access takes place. And once an access agreement is in place, it could remain in force for quite a long period, so potentially up to 2 years.
That's really important, isn't it? It's really essential for employees to understand that we're not just talking about short-term arrangements here or occasional visits, are we?
Yeah, exactly. Um, and for schools, that raises practical questions about how you accommodate regular access alongside timetables, teaching commitments, and day to day operations. So the focus is likely to be on agreeing arrangements that work in practice. For example, making sensible use of digital access, being clear about timing, and really just, I suppose, ensuring the process is manageable on both sides over time.
Yeah, thank you, Ellie. I agree with all of that. It's really interesting. Let's turn then to the second change we're going to cover in today's episode, and that's the duty to inform workers of their rights to join a trade union. Lorna, do you want to come back in here and just take us through what this involves?
Yeah, certainly. So the duty to inform workers introduces a requirement for employers to provide workers with a written statement informing them of their right to join a trade union. Now, it's expected that that will be provided alongside the Section 1 statement at the outset of employment and then reissued again at regular intervals. And those intervals will be set out in secondary legislation.
This then is about increasing visibility and awareness, I suppose. And I think it's probably also worth saying that the government's current thinking is that there's going to be a standard form of wording that the government will provide and that employers will then be required to tailor an issue. But we are still waiting for the outcome of that consultation and the final detail to be confirmed.
Exactly. So even in workplaces where there hasn't historically been a union presence, this is likely to raise awareness and potentially prompt a lot more interest among workers.
And I suppose then that leads us nicely into what employers should be doing now. So before these changes come into force, it feels like there's an opportunity here to take stock and plan next steps. So, Ellie, I wonder what you would be advising clients to do at this stage.
Yeah, I think the starting point is understanding your workforce. Are there signs of union interest already? And if so, which groups of staff are most likely to be affected?
And then what about employers where there isn't currently any union presence?
So, for those employers, it's a really good opportunity to look at your existing staff engagement structures. So, do consultation groups that you currently have feel meaningful? Do staff feel listened to? Is there an information vacuum? Are concerns being addressed effectively? If those mechanisms are working well, they can be a real strength for employers. But if not, really now is the time to strengthen them.
Yeah, I think that's a really good point, Ellie. And I suppose going back to Lorna, I suppose the other thing to just touch on is around how all of these union changes aren't necessarily saying that employers should be viewing these as negatives. And actually, is there an opportunity here in terms of positive workforce relations?
I mean, these reforms strengthen trade union access, but trade union relationships themselves are not something to be viewed as inherently problematic. In many organisations, they provide a real structured and constructive way of engaging with the workforce and also resolving issues.
Yeah, and I suppose in some cases there are even practical advantages of a positive union relationship.
Yes, indeed. And interestingly, in some of the other parts of the Employment Rights Act, there are mechanisms that will allow certain arrangements to be agreed through collective agreements with trade unions, such as the right to contract out of those really complicated 0 hours provisions. And so having an effective union relationship in place can, in some cases, such as that, make aspects of workforce management more straightforward.
Yeah, I think that's right. And that's a really important point to note, Lorna. And so, if we pull all of this together, then I think the key message from today is really about preparation. So, that new right of access and the duty to inform workers of their right to join trade unions, they're likely to increase awareness and engagement with trade unions, of course. But employers who are taking the time now to understand their workforce, look at how they engage with staff and think strategically about how they would respond to union interests. Those are the employers who are going to be in a much stronger position, I think. Lorna, are there any final thoughts that you'd like to share?
I mean, I think for me, it's about not seeing this purely as a compliance exercise. These changes are going to bring trade unions into much clearer focus in a lot of workplaces. So I think it's just worth thinking now about how you would want that relationship to really work in practice.
Yeah, that's really helpful. Thank you. And Ellie?
Yeah, I'd agree with that. From a school's perspective in particular, it's about making sure your internal structures are working well, whether that's communication, consultation, or staff voice. So then, if there is increased union interest, you're starting from a strong position.
Yeah, I think that's really helpful, Ellie, and thanks to both of you for your insights, and thank you to our listeners as well for joining us today. So all that remains for me to say is please do like and subscribe to our Workplace Compass podcast series if you found this episode helpful. Next time, we're going to be looking at trade union recognition and how that process is changing under the Act. So until then, take care, everybody, and bye for now.
Bye.
Bye.